Hi everybody, this is Scotty, and today I'm going to be going over Presentation 3, Predictive Research and Analysis. So the jurisdiction that I chose is Washington State, and I already have that chosen here. So let's start with the search. I wanted to find a case where someone tried to use the intoxicated defense, or if someone recovered any damages from a civil suit where the party or parties were intoxicated. So I just used root expanders for intoxicated liability and recover. So let's see what we find when I search for those. So I'll go to the left and go to cases, and there are a lot of cases that come up. And I went just a little bit further. Under narrow and under reported status, I chose reported to make sure that the case that I chose was published in the books. So this is the case I chose, Gershwin versus Flanagan. I chose this case because it had most of the words that I was looking for, like intoxicated, recovering, intoxication, recovery. So that's why I chose this case. So in this case of Gershwin versus Flanagan, the intoxicated defense was not used, but both of the parties were intoxicated. So while intoxicated, both of the parties, Gershwin and Flanagan, they both got into the car and crashed into a telephone pole. As a result, Flanagan, the driver, died, and Gershwin, the plaintiff, he was a passenger and he was severely injured, but he lived. Gershwin sued Flanagan's estate for damages resulting from the accident. It's interesting to note that Flanagan's blood alcohol content at the time of the accident was 0.38. Gershwin's, the plaintiff, blood alcohol content was 0.17, so significantly lower than Flanagan's. So the two issues in this case are, one, can a negligent passenger ever be more at fault for their injuries than a negligent driver? And two, does RCW, and RCW is the revised Code of Washington annotated, does RCW Title 5, Chapter 40, Section 60 prohibit recovery to an intoxicated passenger when the intoxication was a proximate cause of his or her injuries, and the passenger is found to be more than 50% at fault for those injuries? The court said yes in both questions. So in Washington, you can be found more liable for injuries or death than a negligent driver, and the statute does prohibit recovery if you're intoxicated at the time of the incident. So from there, I looked up the revised Code of Washington, and I'll just type it in the search. And it'll take me straight to the statute, which I think it's cool. Oh, I'm sorry. I did that wrong. Sorry. I missed a period. So it'll take me straight to the statute here. So I go a bit below, and it does say, so it says subsection 1 of this section does not create a defense against the action, notwithstanding that a person injured or killed was also under the influence, so long as such person's condition was not a proximate cause of the occurrence causing injury or death. So, Gershwin admitted that he thought it was safe to drive with someone if they aren't falling down drunk. He said that even though Flanagan was overbuzzed, he quoted, quote, overbuzzed, he chose to get into the car anyway. Even though he knew it wasn't a good idea, he still did it. So that's why the appeals court, this is a Supreme Court case, I'm sorry, by the way, that's why the appeals court ruled that he could not recover any damages and that he was more than 50% at fault. The courts in Washington have held for a while that a passenger may be found to contribute to their own injuries by voluntarily riding in the car with a passenger known to be reasonably intoxicated, which Flanagan was. His blood alcohol content was 0.38. The court said that when a person has voluntarily engaged in behavior which increases the risk of injury, they may be held predominantly liable for the injuries occurring as a result thereof. And they cite Shorter versus Jury for that. in the end, the court decided that they would reverse part of the appeals court decision. But more importantly, which is more important to our case than Jason versus Mark, they affirmed the appeals court decision that the revised code of Washington 54060 properly applies to this case and acts as a bar to the plaintiff's recovery. So Gershwin lost this case. He could not recover anything because he was intoxicated at the time of the incident. So going off of this case, the judge probably would not grant Jason recovery. Both Jason and Mark were probably intoxicated to some degree. Jason is more liable for his injuries because he actually hit. In Washington, it does not matter what your injuries were. The statute clearly states that if you're intoxicated too, the person who injured you or caused death was intoxicated, and you were more than 50% liable for your injury, you cannot recover any damages from that person. So we can say that Jason was more than 50% liable because he didn't act, if he didn't act to be hit, or he would have left Mark alone when Mark said, no, I don't want to hit you, then this probably wouldn't have happened. So that's why I use this case, because in a civil case, you cannot cover damages if you were intoxicated at the time of the incident. But I still wanted to find a case where consent was an issue to assault. So to find this case, it was a bit complicated, the search was, but I wanted to be really specific. So this is what I typed in. I first used a connector ampersand to search for the words assault and consent, because I wanted to know if there are cases that involved consent as an issue to assault. Secondly, I use a root expander for the word intoxicated, a placeholder for the word drink, and I just plainly search for the phrase under the influence. And I wanted to use some synonyms for playing within that same paragraph. So in parentheses, I put joke, game, playing, and rough. So let's see what happens when I search for those terms. Okay, so very quickly, I want to go over this case. I'll go to cases, and even though that I know that this is reported, published, I'll go ahead and click on it anyway. Okay, so I chose this case because it had most of the words that I was looking for, except for intoxicated, drink, and under the influence. But it had assault, consent, game, and those are what I was looking for. So, in this case of State versus Shelley, this is a criminal defense case. But in this case, the defendant, Shelley, he was playing a game of basketball when he hit another player and broke his jaw in 3 places. He hit him intentionally. He said that the other player was playing very aggressively and accidentally scratched his face by accident. He admitted that he reacted and hit the other player out of anger. Shelley's defense was that when someone plays a game, especially when the physical contact is involved, they basically consent to being assaulted, which is a horrible defense in my case, because he admitted, one, that he got angry and he did unreasonable damage to him, but him being hit was not a part of the game. So in this court, they ruled that consent is an issue to assault, and it's consistent with the law of assault in Washington. But a person is guilty of second-degree assault when they intentionally assault another player and it causes substantial bodily harm. So in our case of Jason versus Mark absolutely inflicted substantial bodily harm. But Jason did consent to being hit, although he was hurt beyond what he originally thought. But he did say he can take it, although. The thing is that Jason never used the words punch me in the stomach. He grabbed Mark's wrist and put it towards his stomach, but he never objected to being hit anywhere else. So I think that can be used to Mark's defense. But this case is a criminal matter. In our case, a civil where Jason is suing for damages. The appeals court said that Taking Shelley's version of events as true, the magnitude and dangerousness of Shelley's actions were beyond the limit. There is no question that Shelley lashed out at Gonzalez and with sufficient force to land a substantial blow to the jaw, and there is no question but that Shelley intended to hit Gonzalez, so he hit him because he wanted to, because he was mad. With this defense, an ordinary person should understand that intentionally punching a person in an athletic competition may result in criminal prosecution. So Shelley lost that case. If our case in Jason versus Mark was criminal, then maybe Mark would have been convicted of second-degree assault. But since our case is civil and Jason is suing for damages, I would say the Gershwin versus Flanagan would be the case that we could use for the court to rule in our favor. That wraps up my presentation. I hope that's clear to you all. Thank you for watching. I have absolutely no problem with being wrong or being corrected or taking suggestions. So if there's something in my case that I should go back or go back to or look over, please let me know. And thank you for watching, and let me know what you think. Thank you.